A better understanding of how the tribunals is constituted, their role will be better understood after this chat with my guest, a legal practitioner, Barrister Agbaka. He sheds more light into the role the Election Petition Tribunal will play during this election. Take a listen.
The operative word there being election tribunal, it presupposes that there must have been an election. And it is after this election that the aggrieved person will, through his counsel or himself, petition, by way of petition, initiate a process against his either disqualification or failure in the election. But there are some other matters that comes up that are incidental to and seriously connected to the main election. And that's what brings us to pre-election. And those cases are the cases that you ordinarily take to court before the tribunal is set up. For instance, if there is an intra-party issue where you are refused to participate, that which borders on your fundamental human right, on the basis of that intra-party dispute, the court will assume jurisdiction. Even though the constitution is very clear that it's only a political party that can sponsor a candidate as envisaged under the provisions of the Constitution and the Electoral Act. Meaning that intra-party dispute does not ordinarily face jurisdiction in court, save and except there is an allegation of breach of fundamental human rights. And there have been cases and a derogation or a breach of the constitution of that particular party. But in outside or in the absence of the two conditions and others which I have just stated, then the High Court or nay, the Federal High Court will not have jurisdiction to entertain the matter.
Right, so at what point now will they start their responsibility?
Yes, after the elections, immediately after the elections, they will begin to sit. Because it is only after the election that an aggrieved person will exist, not before.
The Chief Justice of Nigeria has warned the members of the tribunal to make sure politicians or the organizations do not influence their decisions. But really, how can that be avoided?
The truth of the matter is that we have dubious and fraudulent politicians. That is why in the advanced climes where we borrowed our democracy, when you say somebody talks like a politician, you are not saying that he talks like a liar. You are not saying that this person is somebody who is full of broken promises. You are saying that he has the oratory power to express what he has in stock for the people. But contrarily, in Nigeria, when you say you talk like a politician, you are directly telling the person that you're a liar. You talk like a liar. You are full of broken promises. So having that at the background, you will know that even the saint, to a certain extent, will want to be influenced. I am not holding brief for the politicians because they are, what we play to a certain extent is dirty politics. But when we begin to play politics of conscience, and when we begin to conscientize the people, then our approach will be different. And that transparency will inure to that of the benefit of the judiciary. But having said that, you see, the tribunal is not constituted by an individual. And no matter how you're trying to influence a system, there are certain truths that you cannot sweep under the carpet. But I do know that we have men of integrity in Nigerian judiciary. But the point too is whether the appointment or constitution of the panel is really transparent or made on the platform of meritocracy. If meritocracy is considered, we have enough sufficient judges that can dispassionately decide cases. And even the man in the street will be satisfied that justice is not only done, but justice has been seen to have been done.
I know that judges from the High Court, from the Supreme Court, and even magistrates have been appointed. What is the criteria used in appointing the members of the tribunal?
One, the person must be a sitting judge of a state high court or a federal high court. And before you become a judge, there is condition precedent. You don't just pick somebody from there and say you want to be a judge. Minimum of 10 years and the other qualities. And even the background records and other things are actually considered. So in my mind, if a judge is qualified to be a judge of a high court, there is nothing that will inhibit him or her from discharging that duty properly. And then the issue of political influence, I leave that to the conscience of the members of the panel. But the man at the head, the Chief Justice of the Federal Republic of Nigeria, has dished out a warning. And so if you have credible and verifiable evidence, indicting as it were a member of a panel, then you can not only appeal, but you can petition against that person with supportive evidence.
Now, how will the judiciary manage the inflow of cases, considering that a large chunk of about 200 members of the judiciary have been moved to the Electoral Petition Tribunal?
The beauty of it is that some cases that are not part-hard, you can, at that point, depending on the urgency, apply to the Chief Justice of the states where the judge or the case is pending, or the administrative judge of the Federal High Court, depending where your particular case is pending, for an assignment with an application or a motion showing the urgency that case deserves. There are some cases that ordinarily you can wait because there is no urgency attached. But all those cases that attracts urgency, that must be passionately and dispassionately determined within a specific time, the Chief Justice of that particular state will reassign it to another judge for the purposes of dealing with the matter effectively and effectually.
Some people are clamoring for a postponement of the elections, basically because of the fact that a lot of people have not gotten their PVCs.
Those who are saying postponement, they may have been sponsored by a certain group of persons. And one question will be, what will they be asking for? Postponement will bring some constitutional crisis, which may either elongate the tenure of the sitting president or usher in a new legal order. And that might be their motive. Because the reason is that the postponement is uncalled for. It is not necessary. And the reason is that if you have 4 years to prepare for an election, and you go into a deep sleep and slumbered for 4 years, you did not come up with a credible election. Is it 2 days or 2 weeks that you'll be able to tidy up your house? It cannot work. The advocates of postponements are only doing that out of self-aggrandizement and ill motive. If you postpone it for the next 20 years, many Nigerians will not still get their PVC. I think the proper thing will be declare a public holidays, even if it's 2 or 3 days, to enable those who are tied to their jobs have the opportunity of going to that place and getting their PVC. Because if you look at even the registration, if you register in Antony, like I work in Antony, I live in Bagada, that means that day I must come to Antony and remember that there is restriction of movement. But if you have a proper database, it's same material where you register, because only one signature, only one thumbprint will show in the system. So even if you register here and you go to Kaduna, it will show. But unfortunately, we are not prepared for the modern technology. If we are, we would have embraced that. So it's ill-timed, the postponement. If they had said that earlier, maybe 2-3 months before the election, one will begin to look at the things. But remember too, that INEC have not specifically come out to say we need postponement. So who is asking for this postponement? Because if you're asking for postponement, you're asking for postponement because the man who is asking for postponement will be able to tell you the duration of time he requires to ameliorate these anomalies. Jega has not come out to say, I need 2 days, I need 4 days, I need 1 week, I need 1 month to enable me tidy up. Jega and others said, we are ready for the election. We will be able to distribute it